My husband spent 2 years moving our money, rewriting our history, and telling everyone I was unstable. He forgot that I had been an accountant for 15 years. My father was a mechanic. He came from Busan in 1983 when he was 26 years old with a trade qualification and a practical understanding of engines, and a belief not ideological, not rhetorical, just functional and true, that the people who understood how things actually worked would always have ground to stand on. He settled in Howick, East Auckland, in a community of Korean families who had come for similar reasons and who had built over the decades the specific kind of neighborhood that forms when people who share a language and a set of values and a history of having worked hard for things find each other in a new place. He ran a small garage for 31 years. He was not rich. He was careful. He had 2 daughters. I am the elder. My name is Sujin Park, and I am 41 years old, and I have been an accountant for 15 years. And the reason I became an accountant is a sentence my father said to me when I was 14 years old, sitting at the kitchen table while he was looking at the workshop's books. He said, "Sujin, in this life, the person who understands money will never be left behind." He said it in Korean, which is the language he said important things in. He said it with the matter-of-fact quality he brought to everything that mattered, not as wisdom, not as advice designed to be memorable, just as an observable fact about the world that he had established through 31 years of practical experience and wanted to transmit to his daughter before the opportunity passed. I became an accountant. Not because the sentence was inspiring, it wasn't particularly. It was practical. I became an accountant because I was good with numbers, and because the sentence had given me a framework for understanding why being good with numbers was worth something. I graduated from the University of Auckland in 2005, passed my chartered accountancy exams in 2007, and have been working in the industry since then 15 years, in a mid-sized audit firm in the CBD, the kind of firm that does not have the prestige of the Big Four, but does have a quality of work that I find genuinely engaging, and a client roster that keeps me interested. I am not a high-profile accountant. I am the kind of accountant who is very good at her job and who does not particularly want to be known for being very good at her job, because the work itself is sufficient reward, and the performance of capability has always struck me as a form of inefficiency. I married Brendan Walsh in November 2010 at a small ceremony in Devonport that he had organised because he was better at organising social events than I was, and because we had agreed early in our relationship to allocate responsibilities according to comparative advantage. It was a good ceremony. The weather was what Auckland weather is when it decides to cooperate, clear and warm, the harbour visible from the venue. The kind of afternoon that makes people feel that they have made the right decision. From the week we returned from our honeymoon, I kept a folder. I labelled it Marriage Financial. It was a physical folder, initially cream-coloured A4, the kind you buy in boxes of 10 from warehouse stationery, and it contained the documentation that 2 people generate when they combine their financial lives. The joint account statements, the mortgage documents, the insurance policies, the investment account summaries, the tax returns we filed jointly, the receipts for significant purchases. Over the years, it became a box, and then 2 boxes, and then a filing system in the second bedroom that Brendan had once called, with the affectionate exasperation of a man who has married someone who organizes things differently than he does, your archive of everything. He was not wrong. I kept it because I'm an accountant, and accountants keep records. I kept it because my father had told me that understanding money meant tracking money, and tracking money meant having the documents. I kept it because the alternative, the comfortable trusting assumption that everything would be fine and there would be no need to look, had always seemed to me a form of wishful thinking that my profession had specifically trained me to distrust. I did not keep it because I suspected Brendan. I kept it because that is what you do with things that matter. 13 years later, on a Tuesday evening in August, I would be very glad that I had. Let me tell you about Brendan Walsh because I think he deserves a fair description. He was, when I met him, the most immediately appealing person I had encountered in my adult life, not in the shallow sense of surface charm, though he had surface charm in abundance, but in the deeper sense of someone who made you feel, when he was paying attention to you, that you were more interesting than you had previously believed yourself to be. He asked questions that were genuine. He remembered what you said. He had the specific quality of ease that comes from growing up in a family that was comfortable enough that comfort itself was not a project, a quality that is attractive. I have since understood, partly because it is real and partly because it produces a warmth that is available without effort, which is not the same as warmth that has been earned. He was 44 years old and the general manager of a medical equipment import company. He was good at his job, in the way that commercially oriented people with strong interpersonal skills are good at it through relationship building, through the specific art of making clients feel that choosing his company was the right choice, through a combination of genuine product knowledge and the ability to deploy it at the right moment in the right register. He earned well. He managed money confidently in the way of someone who has always had enough and has never needed to count it carefully. This last quality, the confidence with money that does not require careful counting, was, I understand now, part of what made our arrangement possible. I managed the detail. He managed the picture. I tracked the household accounts. He directed the investment strategy. He chose the mortgage broker. I read the mortgage documents. The division seemed reasonable, and for several years it was reasonable in the way that most marriages are reasonable when the people in them are broadly well-intentioned, and the structural incentives have not yet created a reason for the intention to fail. When the incentive arrived, I did not see it coming. Not because I was not paying attention, because the incentive was external to our marriage, a person, not a calculation. And I had been paying attention to the calculations, which were in fact behaving in ways I had noticed without yet interpreting correctly. I want to be honest about this. There were signs in the financial record before the message appeared on the phone. There were transfers I had noticed and filed without fully processing. There was a pattern I had seen and attributed to business expense management before I understood what it actually was. I am a professional who reads financial patterns for a living, and I missed it for almost a year, and the reason I missed it is that I was not looking for it because I trusted him. And trust is the specific cognitive state that is most vulnerable to the kind of deception that is conducted slowly, incrementally, over a long period by someone who knows you well. I do not say this to excuse anything. I say it because it is true, and because I think the truth is more useful than the comfortable version in which I would have seen it sooner if I had been more vigilant. I saw it when I was meant to see it, not a moment before and not a moment too late. It was a Tuesday evening in August, the 4th Tuesday of the month, which was when Brendan usually played five-a-side football with colleagues from work. He had come home at the usual time, showered, and come to the kitchen where I was making dinner. A Korean dish my mother had taught me, the kind that requires attention and produces a smell that I associate entirely with her kitchen in Howick, and with the specific quality of safety that smell represents. He had left his phone on the kitchen bench when he went to get changed. I was not looking at his phone. I was at the stove. The phone was in my peripheral vision on the bench to my left, screen down, and then a notification arrived and the screen lit up and I saw the preview of the message before it faded. I'm not going to tell you what the message said, because the specific content belongs to a part of the story that is not mine to tell publicly. What I will tell you is that it was sufficient. It was more than sufficient. It was the kind of message that cannot be misinterpreted, that admits no innocent reading, that tells you in approximately 30 words something that changes the entire context of the preceding 13 years. I read it. I looked away. I went back to the stove. When Brendan came back into the kitchen, I was stirring. I smiled at him. He sat at the bench and talked about the football, who had played well, a dispute, about a goal, the usual texture of a Tuesday evening in a kitchen with a person you have been married to for 13 years, and who has, just without knowing it, provided you with the piece of information that reorganizes everything. We ate dinner. We watched television. We went to bed. After Brendan was asleep, I got up quietly and went to the second bedroom. I opened the filing system. I found the box labeled 2021 to 2023, and I sat down on the floor with it, and I began to read. I read for 3 hours. What I was looking for I had not articulated to myself yet. What I found was the pattern I had noticed before and not interpreted the transfers, the timing, the specific structure of outflows that did not correspond to any expense category I could identify in our shared life. I found it now, the way you find things when you are looking rather than filing, as a coherent sequence, a structure that had shape and direction and a beginning point approximately 2 years ago. 2 years ago. I sat on the floor of the second bedroom at 1 a.m. with 13 years of financial records around me, and I understood with the specific cold clarity of a professional who has just understood something she should have understood earlier, that the message on the phone was not the beginning of what was happening. It was the visible edge of something that had been happening for 2 years, largely in the financial record I had been keeping, and had not been reading as what it actually was. I am an accountant. I got up. I made tea. I sat at the desk in the second bedroom and I started to work. I gave myself 3 weeks. This was a decision I made that first night, sitting at the desk with the tea going cold and the files open around me. I would not act until I understood what I was acting on. I would not confront Brendan, would not call a lawyer, would not say anything to anyone until I had read the full record and understood as precisely as my professional training allowed what had been happening. This required a specific kind of discipline that I want to describe, because I think it is the most unusual thing about the weeks that followed. I was living with someone who had been deceiving me. I was having dinner with him, watching television with him, saying good night and good morning to him. And in the second bedroom after he was asleep or before he was awake, I was reconstructing the financial architecture of our marriage with the methodical attention of someone conducting an audit. Because that is what it was, an audit of a marriage. And an audit requires the auditor to hold their conclusions until the evidence is complete, because preliminary conclusions distort the reading of subsequent evidence. I held mine. What I found across 13 years of joint account statements was this. The joint account had always received Brendan's income and a portion of mine, about 60% of my salary, with the remainder going to my personal account, an arrangement we had established early in the marriage, and that I had always understood as a sensible hedge against complete financial interdependence. Brendan's full salary had gone into the joint account throughout. From the joint account expenses were paid mortgage, utilities, groceries, holidays, the standard costs of a household. The amounts were consistent, and I had always assumed complete. They were not complete. Beginning approximately 26 months ago, October, 2 years before the message, a new pattern appeared. Regular transfers quarterly, initially, then monthly. Not large amounts individually, 3,000 here, 4,000 there, but consistent. And directed each time to the same account number, an account I did not recognize, and that appeared nowhere in the financial documentation I had accumulated over 13 years of our shared life. I added them up. In 26 months, $63,000. $63,000 had left our joint account over 26 months and gone somewhere I had never seen documented in a pattern that was too regular to be casual expenditure and too structured to be random. I was looking at deliberate transfers. I was looking at a man who had been for just over 2 years, moving money out of the account that was supposed to be ours and into somewhere I was not supposed to see. I took notes. I dated everything. I highlighted the relevant entries in the statements. I cross-referenced the amounts against the calendar, against business trips, against the dates of events I remembered from those months. I built a timeline that ran from October 2 years ago to the most recent statement. Then I looked at it from the beginning, and I thought about what a forensic accountant would say if they saw what I was seeing. And I thought about calling Ji Young. He told me on a Saturday morning in October, 6 weeks after the message on the phone. He had been in the interim entirely normal, the version of himself that I had always known present and warm and unremarkable in all the specific ways of a person who is not aware that anything has changed. I had been in the interim entirely normal in return. I had been to work every day, made dinner 4 nights a week, gone to a friend's birthday dinner, had a conversation about whether we should repaint the lounge. I had been entirely normal in the way that is possible when you have separated the emotional fact of what you know from the practical project of what you are doing about it. He sat across from me at the kitchen table on Saturday morning with the quality of someone who has prepared themselves for a conversation, not nervous exactly, but organized, the quality of someone who has rehearsed. He said he wanted to talk about the marriage. He said it had been difficult for a while and that he had been doing a lot of thinking. He said things about connection and compatibility, and a phrase I had heard before, not from him, from the general vocabulary of these conversations about having grown in different directions. He was not unkind. He was measured and careful, and delivered all of it in the tone of a man who has decided that honesty is the appropriate instrument for this situation, and is using it with the specific care of someone who is not being fully honest. When he had finished, he proposed a settlement. She keeps the house. He keeps the investments and business interests. He described the house's value just under $600,000, with the mortgage leaving approximately $340,000 in equity. He described the investments and business interests, a figure of approximately $380,000 according to the documents his lawyer would be providing. Broadly even, he said, fair given the respective contributions. I listened to all of it without speaking. When he finished, I said, "Have you spoken to a lawyer yet?" He said no, he had wanted to talk to me first. I said, "That's thoughtful. Give me some time to think about it." He nodded. He seemed relieved, the specific relief of a man who has said a difficult thing and found it received without drama. He made more coffee. We spent the rest of the morning in the house in the way of two people who are no longer what they were to each other and are managing the distance between that fact and the ordinary texture of a Saturday. That afternoon, while he was out, I called Margaret Tran. Margaret Tran's office was in Ponsonby, a terrace house that had been converted with the specific quality of Auckland professional offices that occupy old villas into something that was both functional and aesthetically considered, without trying too hard. I had been referred to her by a colleague at work whose sister had used her in a property dispute and described her as the kind of person you want on your side when someone has decided you're not going to understand what's being done to you. I met her on a Monday afternoon, and I told her everything in sequence: the message, the 3 weeks of reading the pattern in the statements, the $63,000, the proposed settlement. I laid the folder on her desk, not the full archive, but the summary I had prepared, the timeline, and the highlighted statements and the cross-references. She read it without speaking for 20 minutes. Then she said, the figure he quoted for investments and business interests. Where did that come from? He said his lawyer would provide documentation, I said. She looked at me over her glasses. Before we see that documentation, do you have any sense of what the actual figure should be? I told her about the transfers, the $63,000, the unrecognized account. She wrote something in her notebook. Then she said, I'd like you to meet a colleague of mine. His name is Tom Reeves. He does forensic accounting work. Before Craig Horton's documentation arrives, I think it would be useful to have Tom look at what you have. I'm an accountant, I said. I've looked at it. You're an audit accountant, she said with the precision of someone who means a distinction and is making it accurately. Tom does forensic. He'll look for different things. Craig Horton's letter arrived the following Thursday. The proposed split was exactly as Brendan had described: house equity at approximately $340,000, investments and business interests at approximately $380,000. The documentation Horton provided was comprehensive in its presentation, and I read it 3 times with the professional attention I had been applying to everything over the preceding weeks, comprehensive in a specific way that I had learned to be suspicious of. It was comprehensive about the things it included. It was silent about whether those were all the things that existed. Numbers that are too clean. That was the phrase I kept returning to as I read Horton's documentation. 13 years of a marriage, a working life, a business career. These do not produce $380,000 in investment assets. They produce more, or they produce less, or they produce something with irregular edges and a complicated history. What they do not produce is a round number in a clean table. I sent Horton's documentation to Tom Reeves that evening. Before Tom's report arrived, I called G Young. My sister was 3 years younger than me, lived in Sydney, and worked in the corporate advisory division of one of the Big Four accounting firms. The kind of work that involves understanding how companies are structured, how assets are held, how the relationships between entities are used to achieve outcomes that are not always apparent from any single entity's accounts. She had been in that world for 12 years, and she had the specific quality of someone who had looked at enough corporate structures to find structural complexity interesting rather than intimidating. I called her on a Thursday evening and I told her everything. She listened without interrupting, which was how G Young listened to important things. When I finished, she was quiet for a moment. Then she said, "Send me everything you have. Statements, Horton's documents, anything related to Brendan's company, any correspondence that touches on finances." I sent it that night. Everything. She called me back 6 days later. "Chioni," she said, the Korean word for big sister, which she only used when something was serious. "I think there's a trust." I was at my desk at work. I put my pen down. "Tell me," I said. "There's a pattern in the transfers that's consistent with regular contributions to a trust structure. The amounts, the timing, the account they're going to, it reads like capitalization, not expenditure. Someone is building something, not spending something." She paused. "I can't confirm it from what you've sent me because I don't have the trust documents. But I can tell you that if there's a trust, it's not in any of the documentation Horton has provided." "Which means it wasn't disclosed," I said. "Which means it wasn't disclosed," she confirmed. "Sujin, you need Tom Reeves to do this properly. I can see the shape of it, but I don't have the tools to find the entity." "He's already looking," I said. "Good." A pause. "Chioni, are you okay?" I thought about the question honestly. "I'm working," I said. "That's the same as okay right now." She understood. She had always understood the way I worked. Tom's report was still in progress when the social campaign began. I noticed it the way I notice most things in the data in the pattern. A friend called to check in with the specific quality of someone who has received information and is conducting a welfare check. a message from a couple we had known for years that expressed concern in the warm but slightly removed way of people who have heard one side of a story and are not sure they are supposed to have heard it. A comment on LinkedIn from a colleague of Brendan's, the kind of vague, supportive post that is entirely deniable as a reference to any specific situation and entirely clear to anyone who knew the context. And from two people directly a version of something I had not expected but recognized immediately concern about my state of mind. Brendan was worried about me, apparently. The separation had been difficult. I was not quite myself. I sat with this for a day. Then I thought about it the way I thought about everything structurally. He was constructing a narrative. Not a dramatic accusation, nothing that could be directly contested. A gentle, sympathetic, concerned narrative in which Brendan was a man managing a difficult situation with grace, and I was a woman who was perhaps struggling emotionally in ways that might cloud her judgment. It was a well-constructed narrative. It served multiple purposes. Simultaneously, it explained in advance any claims I might make that seemed excessive. It positioned him as the reasonable party. It created a social context in which my response to the settlement proposal might be attributed to emotional difficulty rather than professional assessment. I noted it. I did not respond to it publicly. I did not address it in any of the social communications I received about it. I thanked people for their concern with the equanimity of a person who does not need to defend her stability because her stability is evident in her behavior. Then I went back to work. Margaret called me on a Friday afternoon 3 weeks after Tom had started. "He's found it," she said. Tom Reeves was 53 years old, a former Big Four auditor who had moved into forensic accounting work 15 years ago after a case involving a family trust that had been as he described it when he came to Margaret's office to present his findings, structured to be invisible to people who didn't know what to look for. He was compact and methodical and wore reading glasses on a cord around his neck that he put on and took off with the specific regularity of someone for whom the glasses were a working tool rather than an accessory. He had spent 3 weeks with Brendan's financial material. He presented his findings to Margaret and me on a Wednesday afternoon. He had printed the relevant documents and arranged them in a sequence that told the story in order which I appreciated because it was how I would have presented them if they had been mine to present. The Walsh Family Trust had been established in New Zealand 3 years ago. The trust deed had been filed with the company's office under a slightly different naming convention, Walsh Family Trust, 2021, with a reference number that would not appear in a basic search for trusts associated with Brendan Walsh, unless you knew to look at the variant. Tom had found it by following the account number that appeared in the joint account transfer records. The unrecognized account that had received $63,000 over 26 months was a trust account, the same account. The trust's assets as disclosed in the company's office filings that were publicly available but that required specific knowledge of the entity's name and registration number. To locate included the following: investment accounts totaling approximately $420,000, significantly more than the $380,000 Horton had described as the full investment value. A 40% shareholding in Brendan's company, the medical equipment import business that did not appear anywhere in Horton's disclosure. The shareholding had been transferred to the trust 2 years ago at the same time the regular transfers had begun. The estimated value of the business based on publicly available financial summaries and Tom's sector knowledge was approximately $1.8 million. A 40% stake was worth approximately $720,000. Total trust assets approximately $1.14 million. Total disclosed assets according to Horton's documentation, $380,000. The gap between those two numbers, $760,000, was not a rounding error. It was not a matter of valuation methodology. It was assets that existed that had been moved into a trust structure before the separation proceedings began, and that had not been disclosed to me or to my legal representatives in the course of those proceedings. Under New Zealand's Property Relationships Act, 1976, both parties to a marriage are required to make full and frank disclosure of all assets, including assets held in trusts, in the course of relationship property proceedings. The failure to disclose trust assets is not a technicality. It is a serious breach of the obligations the Act imposes, and it exposes the non-disclosing party to significant legal consequences, including the potential unwinding of the trust structure and the inclusion of trust assets in the relationship property pool. Tom presented this in the measured, precise language of a professional report. He said what the documents showed and what they meant and what the legal implications were, and he did so without editorial commentary, because editorial commentary was not his job, and he understood the difference between his job and other people's jobs. When he finished, Margaret looked at me. I looked at the documents. "The transfers started 2 years ago," I said. the same time the shareholding was transferred. Yes, Tom said. He was preparing, I said. The timing is consistent with that, Tom said. I can speak to what the documents show. The interpretation is yours. I looked at the documents for another moment. 2 years. He had been planning this for 2 years, moving assets into a trust structure that he believed I would not find establishing the financial architecture of his exit before he had announced his intention to exit. The $63,000 was the ongoing capitalization of that architecture, regular contributions to a trust account, building the trust's assets on a schedule that would produce a structure worth over $1 million by the time the separation was presented to me. He had done all of this, and then he had sat across the kitchen table on a Saturday morning and proposed a settlement that described our total assets as approximately $720,000. Total disclosed assets, $720,000. Total actual assets, approximately $1.86 million. The gap was $1.14 million. He had proposed to give me $340,000. I sat with that number for a moment. Then I said, "Tell me about the trust deed. Who are the beneficiaries?" Tom opened the relevant page. The beneficiaries of the Walsh Family Trust were listed as Brendan Walsh and any children of Brendan Walsh. I was not named. I had not been named a beneficiary of a trust that had been capitalized in part with transfers from our joint account over 26 months. "Right," I said. I picked up my pen and I looked at Margaret. "What do we do with this?" I said. She had already opened her notebook. There was one more piece. Tom had found the trust and the assets and the disclosure failure, and this was, as Margaret confirmed, sufficient to fundamentally change the proceedings. But there was a question that needed answering before she could proceed with full confidence. Was there any documentation in Brendan's possession that he might use to argue that I had been aware of the trust structure and had consented to being excluded from it? The question was not paranoid. People who plan separations carefully sometimes also plan their documentation, creating a paper record that predates the separation and appears to establish a history that serves their position. "Is there anything you signed in the course of the marriage related to his business structure or any trust or assets arrangement that you may not have fully read at the time?" Margaret asked. I thought about this carefully, and then I remembered. It was the first year of our marriage, 2011. Brendan had been in the process of restructuring his involvement with the company, moving from employee to director, with a partial ownership stake. There had been paperwork, a significant amount of it, as there always is when a business arrangement is being formalized. He had brought it home one evening and asked me to sign several documents explaining that they related to the company's structure and that my signature was required as his spouse to acknowledge the arrangement. I had signed them. I had not read them carefully. I trust this is the sentence that requires the most honesty. I had not read them carefully because he had presented them as routine and I had trusted him. And I had been tired and the documents were long and the explanation he gave was sufficient for me to believe I understood what I was signing. But I had kept copies because I kept everything. I went home from Margaret's office and I went to the archive and I found the 2011 section and I found the subfolder labeled Company Brendan. It contained the documents I'd been given to sign in the first year of the marriage. I had photocopied them at the time, not because I suspected anything, because I photocopied everything and the copies were there in the folder, with my signature on the last page of each. I read them now with the full attention I had not given them in 2011. The document I had signed was not what Brendan had described at the time. It was not a standard spousal acknowledgement of a business arrangement. It was what is called a deed of acknowledgement, a document in which I, as the signatory, acknowledged the existence of Brendan's business assets and stated that I understood them to be his separate property, not subject to the relationship property provisions of the Property Relationships Act. If this document was valid, if my signature on it constituted a legally effective waiver of my rights to a share of those business assets, it would significantly limit my claim against the business interests now held in the trust. I sat at the kitchen table and I read the deed of acknowledgement 3 times. Then I looked at the date. Then I thought about who had been present when I signed it. His name was not on the document. Her name was in the witnessing section, Grace Nakamura. The name meant something to me, but I could not immediately place it. I went to my phone and I called my mother because my mother remembered everything and everyone who had ever been associated with my father's professional life. "Nakamura?" she said when I asked. "Nakamura and Associates. They did bookkeeping for half the Korean businesses in Howick for 20 years. Grace Nakamura, she worked for your father for a while. Lovely woman. She'd be retired now." I thanked her. I called Ji Young. 2011, I said. A deed of acknowledgement waiving my rights to Brendan's business assets. Can he use it? When was the Walsh Family Trust established, she said. 2021, I said, 10 years later. Then the deed of acknowledgement pre-exists the trust by 10 years, she said. It might cover the underlying business assets, but it can't cover a trust that didn't exist when it was signed. The question is whether the deed is valid at all, which depends entirely on whether you had independent legal advice before signing it. I didn't, I said. Then it may not be enforceable, she said. But you need a witness, someone who was there. I had the name. I found Grace Nakamura in 4 phone calls. She was 65 years old and lived in a tidy house in Remuera that she had bought 20 years ago when the neighborhood was affordable, and that was now worth significantly more than she had paid for it, which she mentioned with the mixture of relief and mild bewilderment that people express about Auckland property values when they have been on the right side of them. She remembered me. Sujin Park, she said when I called. Your father was such a good man. I was sorry to hear he passed. My father had died in 2019. She had sent a card to my mother. I explained why I was calling. I was methodical about it, the marriage, the separation, the deed of acknowledgement from 2011 that bore her name as witness. I asked if she remembered the occasion. She was quiet for a moment. I remember it, she said. I wasn't comfortable at the time. I asked her to tell me what she remembered. What she told me was this. The signing had taken place in the evening. At our house, she had been visiting with Brendan and me in connection with some bookkeeping work she was doing for a shared acquaintance, and Brendan had produced the documents toward the end of the visit. He had explained them briefly, the same explanation he had given me, the standard spousal acknowledgement language, and had asked me to sign and had asked Grace to witness. Grace had looked at the document briefly. She had noticed that it was longer and more detailed than a standard acknowledgement. She had thought about saying something about suggesting that perhaps Sujin might want to read it more carefully or consult her own solicitor. She had not said anything. I was a guest in your house, she said. And Brendan was very smooth about it. He made it seem like I was questioning a trivial thing. I have thought about it a few times since. I should have said something. Would you be willing to make a statement, I said, about what you remember of the circumstances of the signing? She was quiet for a moment. The quiet of a woman making a decision that had been waiting for 12 years to be made. Yes, she said. I should have spoken up at the time. I'm glad to speak up now. Margaret spent 2 hours with Grace the following week, taking her statement. What the statement described was precisely what Grace had told me, the rushed presentation of the document, the absence of any invitation for me to read it carefully, or seek independent advice, the social pressure of the occasion, Brendan's characterization of it as routine. These were the conditions that New Zealand courts had consistently held were incompatible with the valid execution of a legal waiver, the conditions of a document signed without full understanding, without independent advice, under circumstances that did not allow for genuine informed consent. The deed of acknowledgement is challengeable, Margaret told me after she had reviewed Grace's statement, possibly unenforceable, which means the business assets, including the interest held in the trust, remain potentially subject to the relationship property provisions. All of it, I said. All of it. Margaret wrote the letter on a Thursday. I had seen her write documents before, had reviewed her correspondence during the proceedings with the professional attention of an accountant who also reads contracts carefully, and I had understood from those earlier letters that her style was a particular kind of precision, not ornate, not performatively learned, just exactly right, every word doing what it needed to do, nothing present that did not need to be there. No emotion, no theatrics, just the specific weight of well-organized facts delivered in the language of the profession. The letter to Craig Horton was 1 page and 3 paragraphs. The first paragraph it enclosed Tom Reeves's forensic report as a complete document with its appendices. It noted the existence of the Walsh Family Trust 2021, its registration number, its disclosed assets, and the estimated value of those assets. It noted that these assets had not been disclosed in Horton's documentation, and that this failure of disclosure constituted a breach of the obligations under the Property Relationships Act. It noted the amount of the transfers from the joint account into the trust account over the preceding 26 months. The second paragraph, it attached Grace Nakamura's statutory declaration regarding the circumstances of the deed of acknowledgement signing in 2011 and noted Margaret's professional opinion that the deed was challengeable on the grounds of insufficient disclosure and absence of independent legal advice. The third paragraph was 2 sentences. We invite your client to consider a revised approach to the relationship property settlement on the basis of full and accurate disclosure of all assets, including those held in trust, before we make an application to the family court for disclosure orders and the inclusion of trust assets in the relationship property pool. We are available to discuss a revised framework at your earliest convenience. No threats, no enumeration of consequences, no indication that we were angry, aggrieved, or anything other than two professional parties addressing a procedural issue that required correction. Margaret sent it by email on a Thursday morning and by registered post the same afternoon. Horton called her on Thursday at 4:57 p.m. He asked for a meeting. Monday, Margaret said. 10 o'clock. She called me that evening. She did not use the word victory, and she did not suggest that the process was over because the process was not over, and she was too precise a person to characterize a phone call from opposing counsel as a resolution. What she said was, "He called, Monday at 10. I expect they'll want to renegotiate the disclosure framework." "What does that mean in practice?" I said. "It means Brendan's lawyer has told Brendan what the trust exposure looks like, and Brendan has decided that a negotiated settlement is preferable to a family court application that puts everything on the public record." I sat with that. "Margaret," I said, "what does an honest settlement look like?" She told me. I wrote the number down. Then I looked at the folder on the desk in front of me. The physical folder, cream-colored, labeled Marriage Financial. The one I had started in the week we came back from the honeymoon, and I thought about 13 years of documents inside it, and in the boxes around it. I thought about what my father had said to me at the kitchen table in Howick when I was 14 years old. I thought he was right. I was not present for most of it, which was Margaret's strong preference, and which I came to understand was correct, not because I was incapable of conducting it, but because my presence would have introduced a register into the proceedings that the proceedings did not benefit from. Horton and Margaret negotiated in the specific professional language of two lawyers discussing a financial framework, and that language was most efficiently deployed without the people whose lives were being reorganized, sitting across the table, bringing the weight of what the reorganization actually meant to them. I was kept informed. Margaret was excellent at this calling after each significant session, describing the positions, explaining the movement. She treated me as a client who was capable of understanding and deciding which I found more useful than being shielded from complexity would have been. What was on the table once Brendan's team had accepted that the trust was going to be part of the discussion was the relationship property pool as it actually existed, rather than as it had been presented. The house, $582,000 value, $240,000 remaining mortgage. Net equity, $342,000. The investment accounts in Brendan's name, $420,000. The trust assets, excluding the business shareholding, were approximately $360,000. The business shareholding, the 40% stake in the medical equipment company, was subject to an agreed valuation process because the business was ongoing and the value was therefore not a fixed figure. The agreed valuation came in at $1.76 million for the whole business, making the 40% stake worth approximately $704,000. Total relationship property, approximately $1.826 million. Under New Zealand's Property Relationships Act, the default position for equal partners in a long marriage is equal division 50% each. Half of $1.826 million was $913,000. Brendan's team did not accept the default position without argument. There were negotiations about the business shareholding, arguments about its illiquidity, about the conditions under which a minority trust shareholding could be realized, about whether the full value was accessible in any practical sense. These arguments had some merit, and Margaret engaged with them on their merits, which is how you negotiate when the underlying position is strong. You don't need to win every point, you only need to ensure that the points you concede don't undermine the position that matters. The settlement signed at the end of 4 weeks was this. I received the house free of the remaining mortgage. The mortgage would be discharged from the trust assets. I received $580,000 from the investment accounts and trust assets. I received a structured payment from the business shareholding based on an agreed formula tied to the company's annual earnings over the next 5 years. The total value of what I received on the agreed assumptions about the business, approximately $1.04 million. Brendan retained the business shareholding and the operational assets associated with it, valued at approximately $780,000 on the same assumptions. It was not an equal split. It was close to one once the structured payment was included in the projection. Margaret considered it a reasonable outcome given the practical limitations of the business shareholding's liquidity, and I trusted her assessment. What it was not was the settlement Brendan had originally proposed. The house at $340,000 against investments of $380,000, a total of $720,000 of which I was to receive less than half. The difference between what he had proposed and what we settled was at the agreed assumptions approximately $720,000 in my favor. Exactly the value of the assets he had not disclosed. The irony of that correspondence, the gap between his proposed settlement and my actual settlement being approximately equal to what he had tried to hide, was not lost on me. I did not remark on it to anyone. I noted it in my own mind with the specific clean satisfaction of a professional who has found that the numbers reconcile. They reconcile. They always reconcile in the end when you have the full set. She came on the first weekend of February, flying up from Sydney on a Friday evening, arriving at my house. My house entirely mine now. The mortgage discharged, the settlement signed with a bag and a box of the Korean snacks she always brought when she was visiting, because she had learned early in her Sydney years that the specific brands our mother had bought were available in Strathfield and not reliably available in Auckland. We did not immediately talk about everything. We ordered sushi. There is a place in Onehunga that has been there for 20 years, and that does the specific thing with the rice that I have never been able to reproduce at home. And we sat at the kitchen table and we ate and talked about Ji Young's work and my work and a renovation our mother was doing to the Howick house, and whether the renovation was a good idea, or whether it was what happens when a 71-year-old Korean woman has too much energy and not enough other things to direct it toward. Then over tea, I told Ji Young the whole story. Not the version she already knew, the summary, the updates I had given her during the process. The full version, from the message on the phone to the 3 weeks of reading to Margaret and Tom and Grace to the 4 weeks of negotiation and the settlement. I told it in order without leaving things out, with the specific quality of someone who has been holding a story at arm's length because it needed to be managed and is now for the first time setting it down and seeing its full shape. Ji Young listened the way she always listened to important things completely, without interrupting, with the full attention that had always been one of the things I valued most about her. When I finished, she was quiet for a moment. Then she said, "Choni, do you know what actually saved you?" "The forensic report," I said. "Tom finding the trust." She shook her head. "Tom found the trust because you gave him 13 years of statements to work from. If you hadn't kept them, there was nothing to work from." She paused. "Brendan moved $63,000 out of your joint account over 2 years, and you noticed the pattern because you had the statements to compare. If you hadn't kept them, that pattern was invisible." "I keep everything," I said. "It's just what I do." "I know," she said. "That's the point. It's not a strategy, it's a habit. And the habit was what made the strategy possible." She wrapped both hands around her tea mug, a gesture I had been watching her make since she was a teenager. The specific quality of someone settling into a thought. "Upper told you," she said. "Right? That's why you are the way you are." "He said the person who understands money won't be left behind," I said. "And you understood that to mean understand it deeply enough to track it." "I was 14, I said. "I thought it was practical advice." "It was practical advice," Ji Young said. "The most practical advice he ever gave either of us." She looked at me. He would be so proud. I thought about my father, about the garage in Howick and the workshop books he had shown me, and the sentence he had said in Korean at the kitchen table when I was 14 years old. I thought about what he had understood without theorizing it, about the relationship between documentation and safety, between keeping the record and having the ground to stand on. He had been a mechanic. He had not been wealthy. He had given his daughters what he could, which was a trade qualification for one and a principal for the other. The principal had held. We stayed at the kitchen table until past midnight. The snacks Ji Young had brought were mostly finished. The tea had gone cold and been replaced twice. We talked about our mother and about Auckland and about what Ji Young was planning to do with the next 5 years. And at some point I realized that I was genuinely not thinking about the settlement or the folder or the 4 weeks of negotiation or any of it. I was just having dinner with my sister. In my house. That was enough. I want to tell you what I know now from this side of everything that happened. The first thing I know is about the folder. I started keeping it in 2010 because I am an accountant, and accountants keep records, and I could not have told you at the time exactly what I was keeping records of or why. My father had given me the principle, and I had applied it with the unthinking consistency of a habit rather than the deliberate construction of a strategy. 13 years of joint account statements, mortgage documents, insurance policies, tax returns, investment summaries. I had not created this folder to protect myself against anything specific. I had created it because it was the appropriate way to treat information that mattered, and the information had mattered from the beginning. The folder was the instrument of everything that followed. Not Tom Reeves, though Tom was essential. Not Margaret, though Margaret was irreplaceable. Not Grace, though Grace's willingness to speak up for what she had seen was the kind of thing that you do not forget. The kind of witness that turns up only when someone has spent 12 years thinking about a moment when they should have said something and is finally given the chance. All of those things were necessary. None of them were sufficient without the folder. The folder was the foundation. The folder existed because I kept records. I kept records because my father told me that understanding money meant tracking it, and I had been tracking it since the week I came home from my honeymoon and bought a cream-colored A4 folder from Warehouse Stationery and wrote Marriage Financial on the label in my handwriting. Brendan had looked at me across 13 years of marriage and had made a series of calculations. The calculations were about what I would and would not notice, what I would and would not be able to prove, what position he would be in when the separation he had been planning for 2 years finally arrived. The calculations were not entirely wrong. He was right that I had not noticed the trust. He was right that the deed of acknowledgement was designed to limit my claim. He was right that a woman without strong documentation going up against a man with a prepared legal strategy and an experienced lawyer would be at a significant disadvantage. He was wrong about one thing. He was wrong about the folder. He had never thought about the folder. I am confident of this, not because I believe he was careless, but because I believe he had in the way of people who have spent their lives being more comfortable than the people around them, never fully registered what I actually was. He knew I was an accountant. He did not know what being an accountant means when it has been your practice for 15 years and your father's principle for your whole life. He underestimated me, not dramatically, not cruelly, in the way that people underestimate the quiet ones, the ones who do not announce their capability, who do not perform their competence, who go about their work without requiring that the work be seen. I had been in our marriage the person who tracked the detail while he managed the picture. He had understood this as a division of labor that served him. It had served him right up until the moment it served me. The second thing I know is about the women in this story. Ji Young, who spent a week with my documents and called me to say, Chioni big sister, the word for something serious, and told me there was a trust when I was still hoping she would tell me there was a simpler explanation. Margaret, who read my summary on a Monday afternoon and immediately understood that the clean numbers were not clean and that I needed a forensic accountant rather than the audit accountant she was looking at. Grace, who had been sitting with 12 years of discomfort about a moment when she had not said something, and who said it when I gave her the opportunity. None of them had any obligation to do what they did. Ji Young is my sister, which creates obligation, but the obligation is general. And the specific act of spending a week reconstructing a financial pattern from incomplete documents is not what general obligation requires. Margaret is my lawyer, which creates a professional relationship, but the specific quality of her attention, the way she treated me as someone who could understand the full picture and decide from it rather than someone who needed to be protected from complexity, that was not a professional requirement. Grace owed me nothing at all. She had been a witness to a document I had signed 12 years ago. She had been uncomfortable about it and had stayed silent, and staying silent is the default human response to discomfort in situations you cannot fully understand. Her willingness to do otherwise when I gave her the chance was the kind of thing that is not inevitable and that I will not forget. The third thing is about what my father meant. He said the person who understands money will never be left behind. I have been thinking about this sentence for a long time, long before any of this happened, and differently since. What he meant by it, I believe, is not that understanding money produces wealth, or that it protects against all losses, or that it makes the people who practice it invulnerable. He was a mechanic for 31 years. He knew better than anyone that understanding something is not the same as being safe from it. What he meant is something simpler and more durable, that understanding, real understanding, the kind that comes from tracking and documenting and refusing to leave things only in memory, produces a form of standing, a position from which you can be heard because you can demonstrate what you say, a form of presence in a world that does not always see you. He was right. I was not left behind. I am in my house, which is mine. I have work that I am good at and that I find genuinely engaging. I have my mother in Howick and my sister in Sydney, and Grace Nakamura in Remuera, who sends a Christmas card every year now, which she did not before. I have the folder which has a new label, just my name now, no longer Marriage Financial, and which I continue to fill with the documents of my financial life. because the habit did not stop being the right habit simply because it was no longer necessary for a specific purpose. Brendan said that we had grown in different directions. He was right about that as well. The last thing I want to say is the simplest one. My father was not a man who built wealth. He was a man who built understanding. He gave it to me at a kitchen table in Howick when I was 14 years old, in a sentence in Korean, in the matter-of-fact way he gave me everything that mattered. In the end, it was enough. It was more than enough.